Good morning, all of you. Today we are going to discuss a very important topic of your syllabus, which is law of the sea. So basically, laws of the sea were initially evolved during the time of Grotius, and they were observed by the states as customary rules of international law. But after the codification, a comprehensive codification of law of the sea, after coming of the United Nations Convention on Law of the Sea in the year in 1982, what specifically are the concepts which were precisely addressed and how the governance of the maritime disputes take place. All these things are addressed by the United Nations Convention on Law of the Sea. And then we are also going to cover a number of concepts which are very, very important to be understood in this particular head. So starting with the same, we all know that sea is a crucial part of human trade and commerce, mineral extraction, power generation, and is also considered as an essential source of blue economy nowadays. So, international law of the sea is a law of maritime space that peacefully settles the global disputes on maritime boundary between or among the states and defines various jurisdictions of the maritime zones as well as the rights and obligations of the coastal states in these zones, especially with regard to the conservation of marine environment and biodiversity. So basically, whenever we talk about international law of the sea, what we need to understand is that it peacefully settles the global disputes on the maritime boundary between or among the states, and it also defines and demarcates various jurisdictions of the maritime zones as well as the rights and obligations of the coastal states in these zones. So it is basically a very comprehensive legislation, the law of the sea. It is also telling us the rights and obligations of the coastal states. Apart from this, it is also telling us how do we need to peacefully settle the global disputes on maritime boundaries, and it is also defining the jurisdictions of the various coastal states relating to the maritime zones. So the law of the sea is a very comprehensive legislation which we need to cover uh, and we need to cover each and every aspect of the same. So it also talks about conservation of marine environment and biodiversity. So basically, the international law of the sea is that part of public international law that regulates the rights and obligations of states and other subjects of international law regarding the use and utilization of sea in peacetime. So it is a very good definition. Basically, this definition is telling us that international law of sea is that part of public international law. It regulates the rights and obligations of the states and other subjects of international law regarding the use and utilization of seas during the peacetime. So it is basically distinguished from the private maritime law that regulates the rights and obligations of the private persons with regard to maritime matters. Example, the carriage of goods, the maritime insurance, all these things, these are governed by private maritime laws because it is specifically talking about the rights and obligations of private persons. It is not talking about the rights and obligations of states. So whenever the term state comes into the picture, international law of sea comes into the picture. So it is very much different from the private maritime law, which regulates the rights and obligations of the private persons with regard to maritime matters. Now, so basically, law of the sea is concerned with the public order at sea, and much of this law is codified in UN Convention on Law of the Sea. Whenever we talk about United Nations Convention on the Law of the Sea, it was the convention which was formulated in the year 1982 on law of the sea. It constitutes a comprehensive codification and development of contemporary international law governing the sea in time of peace. So basically, it is a comprehensive codification of law of the sea. It talks about the development of contemporary international law governing the sea at the time of peace. So basically, the UNCLOS, this particular convention, United Nations Convention on Law of the Sea, it is known as UNCLOS, and basically it is also called as the Law of the Sea Convention. It is kind of a global agreement, and it resulted from the third UN Conference on Law of the Sea, which took place between 1973 and 1982. So basically, why this particular conference is known as third international conference? Because before this particular uh, convention, which was formulated in the year 1982. There were first and second UN conference on law of the sea as well, which were held respectively in the year 1957, in the year 1968. But both these conventions couldn't be codified because they failed to address many important issues that needed to be precisely addressed for the governance of law of the sea. So basically, this particular convention, the United Nations Convention on Law of the Sea, it came into picture in the year 1982. It is a comprehensive legislation, it is a comprehensive codification, and it is very, very important for the governance of the entire issues relating to the seas. So basically, the maritime jurisdictions are now governed mainly by the 1982 UN Convention on Law of the Sea. The comprehensive 1982 Convention on Law of the Sea consists of 320 articles and 9 annexures, and it was concluded in the year 1982. So what are we talking about is that this particular comprehensive codification of law of the sea, it was concluded in the year 1982, and it consists of 320 articles and 9 annexures. So basically, this particular convention is addressing each and every issue relating to law of the sea. Now, there's an international tribunal for law of the sea, which is popularly known as ITLOS, ITLOS. So after the entry into force of the UN Convention on Law of the Sea, there were strong efforts which were made for establishment of an international tribunal for law of the sea. So this is popularly known as ITLOS. Now, in August 1996, there were 21 judges of the tribunals were elected on the basis of equitable geographical distribution. The ITLOS is an intergovernmental organization, and it is created by the mandate of the Third UN Conference on Law of the Sea. So, this particular tribunal, it is an intergovernmental organization, and it is created by the mandate of Third UN Conference on Law of the Sea. It was specifically established by the UN Convention on Law of the Sea, signed at Montego Bay, Jamaica on 10th December 1982. The ITLOS was ultimately established on 21st October 1996, of which jurisdiction is not compulsory and is optional or based on the consent of the state. So it is not having a compulsory jurisdiction, it is based on it is completely optional, and it is based upon the consent of the state, that if the state parties, they want to take their particular dispute to this particular tribunal, this tribunal can have the jurisdiction and adjudicate their dispute specifically relating to law of the sea. So this tribunal, being an intergovernmental organization, has been specifically created for adjudicating the disputes of law of the sea. Now, tribunal is situated in Germany, and it established a global framework for law over all the ocean space it uses and resources. So the tribunal is open to all the state parties uh, to the 1982 UN Convention of Law of the Sea. Who all were the state parties of this particular convention? The tribunal is open to all those state parties, and this particular tribunal, it specifically is not having a compulsory jurisdiction, but its jurisdiction is optional and is based on the consent of the state. So basically, it is an independent judicial body, and it is established by the United Nations Convention on Law of the Sea to adjudicate disputes arising out of interpretation and application of the convention. So this particular tribunal is very, very important from this particular aspect. Now, talking about the United Nations Convention on Law of the Sea, which was formulated in the year 1982, the third one. It has addressed n number of aspects which are very, very important for the governance. So basically, these are the aspects which are very, very important, which has been addressed by this particular convention. The first one is baseline. The second one is inland waters. The third one is territorial sea. The fourth one is contiguous zone. The fifth one is exclusive economic zone. Sixth one is high sea, and the seventh one is continental shelf. So all these concepts are very, very important to understand. Now, let's first have a look at this particular chart, which is explaining precisely that why these areas have been demarcated separately, and what are the measurements which have been allocated to each and every area. So basically, you must there's a baseline. So what is the meaning of baseline? What actually is a baseline? See, baseline is a water line which acts as the acts for the purpose of measuring the starting point from where you start to measure the ocean. This particular thing is known as a baseline. You start to measure the sea from baseline itself. Now from baseline up to the area of 12 nautical miles, that particular area is specifically known as territorial sea. Now from 12 nautical miles up to the area of 24 nautical miles, it is known as contiguous zone. And beyond this, up to 200 nautical miles, there is exclusive economic zone. So these three concepts are very, very important to understand, which we are going to study in detail. But first we need to understand what is a baseline, what is a territorial sea, what is a contiguous zone, what is exclusive economic zone, and what are high seas. So basically baseline is that particular measurement line, from where we start to measure the ocean, and from baseline up to 12 nautical miles we are having territorial sea. After 12 nautical miles up to 24 nautical miles we are having contiguous zone, and beyond this up to 200 nautical miles we are having exclusive economic zone. So these three concepts are very, very important. Now, what after 200 nautical miles? After the area of 200 nautical miles, there are high seas. So, up to 200 nautical miles, each and every country has exclusive economic zone, and beyond this particular area, we are having high seas. Now, you must be noticing that there's a continental shelf, which is basically starting from, which is basically the land area beneath the sea. So the land area which is beneath the sea, this particular area is known as continental shelf, which connects to the deep sea bed. So all these terminologies which was mentioned previously under this, all these terminologies have been mentioned in this chart, and this is very, very important to understand each and every concept relating each and every aspect related to all these terminologies. So there's a baseline, there's a territorial sea up to 12 nautical miles, then up to beyond 12 and up to 24 there's a contiguous zone. Now then after that particular zone up to 200 nautical miles there is exclusive economic zone, and beyond exclusive economic zone there's a high sea. Now the land area which is connected which connects to the deep sea bed, that particular land area beneath the ocean is known as continental shelf. So I hope each and all these terms are very, very clear to you. Now we are going to discuss each and every term in detail. So basically, yes, so specifically we have to discuss all these areas in detail, that why there have been separate demarcations of all these areas by the United Nations Convention on Law of the Sea. So the very first one is baseline. So as I told you, the coastal curve from which the maritime area of a state is measured is called a baseline or the low water line. Article 5, it contains provisions as to the normal baseline and reveals that except where otherwise provided in this convention, the normal baseline for measuring the breadth of the territorial sea is the low water line along with the coast as marked on large scale charts officially recognized by the coastal state. So basically this is a measurement line from where we start to measure the ocean. So basically the coastal curve from which the maritime area of a state is measured, that is precisely known as a baseline. Now, the straight baseline departs from the physical coastline due to certain distinctive features of coast of a state. So basically there can be a straight baseline as well, there can be a curvy baseline as well, so it depends. Now there's a case, Anglo-Norwegian fisheries case. In this case, the Norwegian government delimited its fisheries zone, which is territorial sea, by a decree of 12th July 1935. The area of this delimitation was about 1,000 miles of coastland of its 66.28.2 north latitude. So basically in this particular case, Norwegian government, they delimited their fisheries zone basically by a decree of 12th July. Now the government limit of 4 miles of territorial waters had been established by a royal decree in 1812, and the UK also admitted it. But it was not measured from the low water mark at every point, linking the outmost point of the land and sometimes drying rocks above water only at high tide. The UK, recognizing the claim of 4 miles, challenged the validity of the baseline newly made and laid their grievance in the ICJ for adjudication. So basically, the issue in this particular case before the court was that whether the baselines fixed by the said decree in application of Norwegian method were contradictory to the international law. Now, the court decided by a vote of 10 is to 2 in favor of Norway, approving the practice of Norway of drawing an outer line for its territorial sea that was based on straight baselines following the general directions of the coast, but not the indentation of that particular coast. So basically, according to court, the following reasons were considered to reach this particular decision. The first one, in respect of delimitation of territorial waters with other states, the ICJ observed that the act of delimitation is always an international aspect. It cannot be dependent merely upon the will of coastal state as expressed in the domestic law. So basically, in respect of delimitation of territorial water with the other states, ICJ precisely observed that the act of delimitation is always an international aspect. It cannot be dependent merely upon the will of the coastal state. Then the number two is that coastline of the Norway is not one of the ordinary nature, rather it is of a broken nature. So the court held that the method of baselines employed by the Norway was not contrary to the international law. The special geographical facts involved the economic interest peculiar to the region. So basically, they also mentioned that the coastline of Norway, it is not of ordinary nature, it is of a broken nature. So the court specifically held that the method of the baselines employed by the Norway was not contrary to the international law. The special geographical facts involved the economic interest peculiar to the region. So the case is mainly based on the principle that in some situations the geographical circumstances permit the drawing of a straight baseline in the territorial sea. This method consists of selecting appropriate points on the low water mark and drawing straight lines between them. So the decision of this particular case, it was subsequently accepted by the world community and was incorporated in the 1958 Geneva Convention on Territorial Sea and Contiguous Zone. So basically what we need to understand over here is that in this particular case, there was a discussion on the straight baseline and the curved baseline. So in this case, it was held that the geographical circumstances, they permit the drawing of a straight baseline in the territorial sea. So the decision was specifically in the favor of Norway. So this particular case, it discussed the concept of baseline, which is very very important to understand. And on the basis of this particular decision, this was subsequently accepted by the world community, and it was incorporated in the 1958 Geneva Convention on Territorial Sea and Contiguous Zone. So I hope you all are clear with the meaning of baseline. Now the second one, the very important concept, is inland waters. The internal waters which exist from the baseline to the landward side area of the coastal state are called inland waters. So basically these are the internal waters. They exist from the baseline to the landward side area of the coastal state, and they are called inland water. This particular concept is not that important, but since there is a concept, we must know about the same. So whatever the internal waters which are existing from the baseline to the landward side direction of the coastal state, they are known as the inland waters. So the first one was baseline and the second one was inland water. Now what is a territorial sea? This concept is very very important to understand. That we need to understand that what actually is a territorial sea, and why this particular concept is very important for the peaceful governance. Now when we talk about territorial sea, according to this convention of 1982, Each country has a sovereign territorial water which extend to a maximum 12 nautical miles beyond its coast, but foreign vessels are granted the right of innocent passage. See, what happens is that when we were discussing that particular diagram, the diagram said, it is telling that from baseline up to 12 nautical miles, the area is known as territorial sea, which is also known as territorial waters. So please do not get confused that that the territorial sea and territorial waters are different concepts. These are one and the same things. Now, talking about this, up to 12 nautical miles, according to this particular convention, every state has a right to establish and exercise its supremacy over this particular area up to 12 nautical miles from the baseline. Now, if we are talking about sovereignty, if we are talking about supremacy, so basically in this territorial sea, the country has the exclusive jurisdiction to undertake each and every activity whatever they want to undertake. There is no restrictions regarding this regarding the use of this particular area. Basically, to whatever country it belongs to, they are free to use and exploit this particular area. They are free to extract minerals, materials, and other resources. They are free to explore the biodiversity over there, and each and every rights associated up to the area of 12 nautical miles belong to that particular state. Now, in this particular area up to 12 nautical miles, there is a right which has been granted to other state, which is a right of innocent passage. Now, what do we understand by the meaning of innocent passage? See, passage is innocent as long as the ship refrains from engaging in certain prohibited activities, including weapon testing, spying, smuggling, serious pollution, fishing, or scientific research. So basically, there are some prohibited activities like spying, fishing, serious pollution, smuggling, weapon testing. You cannot indulge into any of the prohibited activities under the jurisdiction of any other nation, which means that if India has exclusive supremacy up to the area of 12 nautical miles, then any other country cannot infringe that supremacy. They only have a right of innocent passage, which means that they have a right to navigate over there. They have a right to pass from there. They have a right to stop and ask for help, but they do not have the right to indulge into any of the prohibited activities like weapon testing, spying, smuggling, pollution, fishing, scientific research, and so on. So basically, right of innocent passage, it is being discussed by Article 17 of the 1982 Convention, and it deals with the right of, and it tells us that subject to this convention, ships of all the states, whether coastal or landlocked, enjoy the right of innocent passage through the territorial sea. So, if any ship belonging to any XYZ nation, they want to exercise this particular right, they can pass through the territorial sovereignty of any other nation. So the 1982 convention, it also contains provisions regarding the meaning of passage. What do we mean by passage? In its article 18, it has stated that passage means navigation through the territorial sea for the purpose of number one, traversing that sea without entering internal waters or calling at the roadstead or post facility outside internal waters, or number two, proceeding to or from internal waters or a call at such roadstead or port facility. Passage shall be continuous and expeditious. So basically, there's a right of innocent passage. The ships can pass according to Article 17 belonging to any XYZ nation. And then in that context, Article 18 is telling us about what is the meaning of passage. So basically, they can traverse that particular sea without entering into their internal waters. They can proceeding to and from internal waters or a call at such roadstead or a port facility. So the passage, it shall be continuous and expeditious. So basically, this is very, very important that the other countries have a right of innocent passage over your territorial sea or territorial water. Now, passage, it includes stopping and anchoring as well, but in so far as the same are incidental to ordinary navigation or are rendered necessary by the force majeure for the purpose of rendering assistance to persons. So passage can also include stopping and anchoring, but it must be incidental at that point of time, that it is necessary by any force majeure, any particular occurrence of an event, and by the occurrence of that particular event, this they are stopping over there and they are anchoring over there. Now, article 19, it is telling us the meaning of innocent passage, and accordingly it is telling us that accordingly it states that passage is innocent so long as it is not prejudicial to the peace, good order, or security of coastal state. So basically, the passage will be innocent till the time it is not prejudicial to the peace, good order, and security of the coastal state. So the right of innocent passage shall no more remain innocent if the peace and security of the territorial sea of the coastal state is hampered by any act of the foreign vessel. So basically, if that foreign ship is indulging into any of the prohibited activities and it is threatening the peace and security of the territorial sea belonging to the coastal state, then that particular passage will not be regarded as an innocent passage. So this is the meaning of innocent passage. I hope this is clear to all of you. Now, there are some obligations of the coastal state relating to the innocent passage. What are these obligations? See, a coastal state has some obligations regarding the innocent passage under the 1982 convention. So regarding the right of innocent passage, article 21 is talking about the same. They have very basic obligations to ensure the security of innocent passage. It lies upon the coastal state. Now again, in article 25, it is talking about right to protection of the coastal state, which states that the coastal state may take necessary steps in its territorial sea to prevent the passage which is not innocent. So basically, they have to ensure the security of the innocent passage as well, and they also have to ensure whether the passage is innocent or not. So basically, they have to take precautionary measures that uh, there might be chances that some of the ships are going to indulge into prohibited activities. So for that matter, they need to take precautionary measures as well. So they have to ensure the security of innocent passage, and they also have to make laws regarding prohibition of passage which is not innocent. Also, the coastal state, without discrimination, they can suspend temporarily in specified areas its territorial sea the innocent passage of foreign ships if such suspension is essential for the protection of its security, including weapon exercises. So basically, coastal states, they also have a right without any discrimination to suspend temporarily in specified areas of its territorial sea the innocent passage of foreign ships if such suspension is essential for the protection of its security, including weapon exercises. So they have to make laws for the safety of innocent passage. They also have to prevent the passage which is not innocent. So they have to make precautionary steps, and they also have the right to suspend temporarily few of the foreign vessels because they feel that there is a threat upon security and peace in their territorial sea region. So for that matter, they can temporarily suspend without any discrimination in form or in fact. So these were the obligations of a coastal state with regard to your right of innocent passage. So I hope right of innocent passage is clear to all of you, and the concept of territorial sea is clear to all of you. Now, shifting upon the next important concept, which is contiguous zone. As we discussed under the diagram, that beyond the area of 12 nautical miles and up to the area of 24 nautical miles, the area which has been specifically marked up to 24 nautical miles is termed as contiguous zone. So basically, when there was evolution of law of the sea, and at the time of Hugo Grotius, he divided the sea on the basis of customary rules of international law in territorial sea, contiguous zone, and high sea. So there was no exclusive economic zone at that point of time when Grotius divided the sea on the basis of customary principles of international law, customary rules of international law. So contiguous zone is not much relevant in the present context after the coming of exclusive economic zone, because when we have a look at the diagram, we will see that the area from 12 nautical miles up to 24 nautical miles is contiguous zone. But the below this there is an arrow which is telling us that from from 12 nautical miles up to 200 nautical miles the zone is exclusive economic zone. So this was an early demarcation. Contiguous zone as of now is now covered under the exclusive economic zone only. But as a concept, why it originated and why it was so important, we need to understand this particular concept. So it is up to 24 nautical miles. Now the use of contiguous zone gives coastal state an additional area of jurisdiction for limited purposes. So basically this particular zone, it is giving the coastal states an additional area of jurisdiction for limited purposes, like article 33 of the 1982 convention. It deals with contiguous zone and reveals in its sub article that in a zone contiguous to its territorial sea described as the contiguous zone, the coastal state may exercise the control necessary to. Now, what are the controls which the coastal state can exercise in respect of this particular zone? The first one is they can prevent infringement of customs, fiscal, immigration, or sanitary laws or regulations within the territory. They can punish for infringement of the above laws and regulations committed within its territory or territorial sea. So basically, for these purposes, we can access contiguous zone, and this is important for understanding the law of the sea. So basically this article 33 of 1982 convention is talking about how do we necessarily exercise control by the way of this particular zone. And again in article 24 of your 1958 Geneva Convention, the same thing was mentioned and the same has been incorporated under the 1982 convention. So basically this is the meaning of contiguous zone. Now coming to the exclusive economic zone, which is very very important. So it is also known as patrimonial sea, the exclusive economic zone. It is very very important to mention one of the cases in order to understand what is exclusive economic zone. So there's a fisheries jurisdiction case, US and Germany versus Ireland. So basically in this case, in the year 1958, following the Geneva Conference, Iceland declared a 12 nautical miles exclusive fisheries zone and the UK accepted it in 1961. So after the Geneva Convention of 1958, after the Geneva Conference of 1958, Iceland, it declared a 12 nautical miles exclusive fisheries zone and UK accepted this particular demarcation which was given by Iceland. Now on 1st September 1972, Iceland announced 50 miles of its water territory for the conservation of economic zone measured from a straight baseline close to the fisheries vessel. Now, again on 14th April 1972, the UK unilaterally inaugurated proceeding before the ICJ, claiming that the Iceland was not entitled to unilateral extension of the zone. So basically these were the claims by UK. On 14th April 1972, UK unilaterally inaugurated proceeding before ICJ, claiming that Iceland was not entitled to unilateral extension of the zone. UK further said that the conservation of the fish stock of Iceland should be subject to bilateral arrangements between the two states. Now at that point of time, court received another issue concerning similar German-Iceland dispute. So there was another dispute of similar nature between Germany and Iceland. So court basically joined both these disputes together. Now, in this case, the core issue before the court was whether Iceland was entitled to the unilateral extension of its economic zone 50 nautical miles beyond its territorial water. So the court by 10-4 held that Iceland was not entitled to declare unilaterally an exclusive fisheries zone of 50 nautical miles beyond its territorial water. The government of Iceland, the UK, and West Germany were under an obligation to negotiate an equitable solution among the same. Now, the decision further said that the preferential rights of Iceland, UK, and West Germany should be taken in account in the negotiation. The reasoning in this case was that ICJ first established the principle of preferential rights over the particular regime of the sea. The court held that 90% of the foreign currency of Iceland is earned from fishing. In fact, the total economy of Iceland depends on fishing. So, for this reason, Iceland was given the preferential right over the particular zone. The court found that the unilateral declaration of 50 nautical miles exclusive economic zone neither legal nor illegal under the principle of international law. So the declaration, the court find that this declaration was neither legal and nor it was illegal. So when the hearing of the case was going on before ICJ, argument about declaration of exclusive economic zone over the contiguous zone became the top issue of discussion regarding the delimitation of international maritime area. So this particular concept, exclusive economic zone, this argument came into picture that we should declare exclusive economic zone over the contiguous zone, and it became the main center topic for discussion. Now, for that reason, many states claimed their right to fishing over 200 nautical miles towards the high seas. Finally, this matter was emphasized and incorporated in the 1982 convention, and it was enacted that the exclusive economic zone shall extend to 200 nautical miles from the baseline from the coastal state, which was a reflection of the creeping annexation rule in international law. So basically, the concept of exclusive economic zone, which we discussed in the chart, up to the area of 200 nautical miles, it was argued that the declaration of EEZ over contiguous zone should be done. And as a matter of fact, under a discussion, by the way of discussion under this particular case, what happens is that the finally this matter was emphasized and incorporated in the convention of 1982, and it was enacted that the exclusive economic zone shall extend to 200 nautical miles from the baseline of the coastline state, which was the reflection of creeping annexation rule in international law. So this particular case, your fisheries jurisdiction case, it is very important, because it originated somehow the concept of exclusive economic zone in international law. So yeah, this particular case is very important. See, there's a mistake over here. It is written US and Germany versus Ireland. Specifically, it is UK and Germany versus Ireland. So there's a mistake. There's a typing error. So please correct this. This is UK and Germany versus Ireland. So this particular case, this basically emerged the concept of exclusive economic zone in international law. So exclusive economic zone is the zone up to the area of 200 nautical miles, and the Article 55 of 1982 convention and Article 57 of Article 55 of the 1982 convention, it provides that the EEZ is an area beyond and adjacent to the territorial sea, subject to the specific legal regime established in this part, under which the rights and jurisdictions of the coastal state and the rights and freedom of other states are governed by relevant provisions of this particular convention. So Article 57 deals with the breadth of exclusive economic zone, and it states that the exclusive economic zone shall not extend beyond 200 nautical miles from the baseline from which the breadth of territorial sea is measured. So what we need to remember over here is that up to 200 nautical miles, the area is specifically exclusive economic zone. Now we need to understand what are high seas. What is the meaning of high seas? Basically, before proceeding with the same, first we should understand that what do we mean, why this particular term high sea has been used, and why there is no demarcation further from exclusive economic zone. So basically, high seas are defined in Article 1 of the 1958 Geneva Convention on High Seas as all the parts of the sea that were not included in the territorial sea or in the internal waters of the state. So the area which is nowhere included within the internal waters, in the territorial sea, in the contiguous zone, or in the exclusive economic zone, this particular area is specifically known as high seas. So basically, high seas is the area beyond the beyond exclusive economic zone, which we need to keep in our mind. Now basically, uh, it lies beyond all the zones which we have described and discussed till now. The waters and the airspace of this area are open to use by all the countries except for those activities which are prohibited by international law. So the waters, airspace of this particular area, it is open to use by all the countries except for those activities which are prohibited by international law. Now, what are the activities prohibited by international law? Suppose, for example, the testing of nuclear weapons. So, it is prohibited that in the areas of high seas, you cannot undertake these activities. Now, if you want to undertake specifically any activity, you must notify the International Seabed Authority, which has the jurisdiction of this particular area. So the International Seabed Authority has the jurisdiction of high seas, and the minerals on the ocean floor beneath the high seas are deemed as the common heritage of mankind. Their exploration is administered by ISA, which is International Seabed Authority. Now, high seas, you just need to remember that the area which is beyond exclusive economic zone of any country, that area is known as high sea, and it is beyond each and every area which we have discussed till now. The water and the airspace of this area are open to be used by all the countries except the activities which are prohibited by international law. Now, this area, the minerals on the ocean floor beneath this particular high seas, they are also known as common heritage of mankind, which you need to remember. And their exploitation, the exploitation of minerals belonging to this particular area, which is termed as a common heritage of mankind, is administered by International Seabed Authority. Now, why it is a common heritage of mankind? Obviously because it is open to be used by all the countries. That is why this area is specifically known as common heritage of mankind. So any commercial exploration, mining of the seabed, it is carried out by private or state concerns, regulated and licensed by the ISA, though thus far only exploration has been carried out. So this is the meaning of high sea. Now, what are the freedoms under the high sea? See, Article 2 of the Geneva Convention on High Seas, which was concluded in 1958, it provided that there are certain freedoms for both the coastal and the non-coastal states, which they will enjoy in the area of high sea. So there are four freedoms which have been specifically mentioned under this particular convention. The first one is freedom of navigation, the second one is freedom of fishing, the third one is freedom to lay submarine cables and pipelines, the fourth one is freedom to fly over the high seas. All these freedoms have been specifically mentioned under Article 2 of the Geneva Convention, and it can be exercised both by the coastal and the non-coastal states. So these freedoms, which are recognized by the general principle of international law, shall be exercised by all the states with regard to the interest of the other state. So when you are exercising these freedoms, you also need to keep in mind the interest of the other states. So in Article 87 of the 1982 Convention, two more freedoms were inserted. Now, what were these two more freedoms which were inserted in the uh, Article 87 of 1982 Convention? Basically, freedom of navigation was the same, freedom of overflight, freedom to lay submarine cables and pipelines, freedom to construct artificial islands and other installations permitted under the international law, freedom of fishing, freedom of scientific research. So your basically construction of artificial islands and installations were permitted, and these were incorporated further under the Convention of 1982. So these are the freedoms which are exercised in the area of high seas, but it should always be kept in mind that the interest of the other nations shouldn't be hampered when you are exercising the freedoms which was specifically mentioned under this particular convention, the Convention of 1982 and the Convention of 1958. So basically, we need to keep these points in our mind, that we are not hampering the interest of any other country by any of the activities conducted by this particular convention. Now, The next important concept which we need to understand is a continental shelf. What is the meaning of continental shelf? We discussed under the diagram that the land which is beneath the ocean and it goes up to the deep sea bed, that particular area is described as continental shelf, if we talk in a layman sense. Now, continental shelf is a geological expression referring to the ledges that project from the continental landmass into the seas and which are covered with only a relatively shallow layer of water and which eventually fall away into the ocean depth. So this is the basic definition of a continental shelf. It is a geological expression. It refers to the ledges that project from continental land mass into the seas and which are covered with only a relatively shallow layer of water and which eventually fall away into the ocean depth. So it is an underwater landmass that extends from a continent, resulting in an area of relatively shallow water known as a shell sea, and a region adjoining the coastline of a continent where the ocean is no more than a few hundred feet deep. So basically it is an area, in a layman sense, you need to understand and remember always that it is an area, land area beneath the ocean, as the definition is telling us that the continental land mass into the seas and they are covered with relatively shallow layer of water and which eventually falls away into the ocean depth. So this is the meaning of continental shelf. I hope this is clear to all of you. Now the article 76 of the 1982 convention, it talks about continental shelf. So the continental shelf of a coastal state, it comprises the seabed and the subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory to the outer edge of the continental margin, or to a distance of 200 nautical miles from the baseline from which the breadth of the territorial sea is measured, where the outer edge of the continent margin does not extend up to that particular distance. So this particular definition is a bit complicated, which you need to memorize. So basically it is a technical definition of continental shelf. You need to understand the basic meaning of continental shelf, which is the area beneath the ocean water, the adjoining land. So basically continental shelf is a seabed and a subsoil of the submarine areas which is adjacent to the coast but outside the territorial sea to a depth of 200 meters or beyond that limit, to where the depth of the superjacent waters admits of the exploration of the natural resources and the said areas, and to the seabed and the subsoil of similar submarine areas adjacent to the coast island. So this is the meaning of continental shelf. This is very, very important to understand that the adjoining land into the deep ocean, this particular thing, the land beneath the ocean, this is known as a continental shelf according to what we discussed in the under the diagram. So this particular area which you can see, the adjoining land which is going up to the deep sea bed, this land is beneath the ocean water, and this particular shelf is specifically known as continental shelf. So this is very, very important to understand. Now we are done with each and every concept which have been incorporated under the United Nations Convention on Law of the Sea. Now what are the rights of the coastal state over the continental shelf? This we need to discuss. This is very important, very, very important. So article 77 of the 1982 convention, it deals with the rights of the coastal state over the continental shelf, and it states that number one, the coastal state exercises over the continental shelf supreme rights for the purpose of exploring it and exploiting its natural resources. So the coastal state, it has the supreme rights to explore that particular continental shelf and exploit the natural resources. The second one is that the rights are exclusive in the sense that if the coastal state does not explore the continental shelf or exploit its natural resource, no one may undertake these activities without the express consent of the coastal state. So if the coastal state, it is not willing to explore the continental shelf or exploit its natural resources, nobody else can undertake these activities without the express consent of the coastal state. The next one is the right of the coastal state over the continental shelf do not depend on occupation, effective or notional, or on any express proclamation. So basically, the rights of the coastal state, they do not, over the continental shelf, they do not depend on any occupation. The next one is the natural resources consist of the mineral and other non-living resources of the seabed and subsoil together with living organisms belonging to the sedentary species, that is to say organisms which at the harvestable stage either are immobile on or under the seabed or are unable to move except in constant physical contact with the seabed or the subsoil. So the what are the natural resources? Basically they consist of minerals and other non-living resources of the seabed and the subsoil together. So basically these are the rights of the coastal state in relation to a continental shelf, that a coastal state exercises supreme rights for the purpose of exploring and exploiting the natural resources of continental shelves. If they do not want to explore and exploit, no other country can do the same without the express consent of the coastal state. The next one is that the right necessarily does not depends on any of the occupation. And the last one is that what are the natural resources? They consist of all the minerals and other non-living resources of the seabed and subsoil together. So all these concepts, now I hope all of you are able to understand the concepts which have been mentioned under the United Nations Convention on Law of the Sea. The first one was baseline, the second one was inland water, the third one was territorial sea, the fourth one was contiguous zone, the fifth one was exclusive economic zone, the sixth one was high seas, and the last one was continental shelf. I hope all these concepts are clear to each and every one of you. If there is any doubt, you can feel free to ask at any point of time. And now the concluding remarks. Now it is apparent from the scrutiny that the law of sea is a burgeoning area of international law. The 1958 and the 1982 conventions on law of the sea did much to create systematic rules for the management and use of the common resource, and many of the rules contained in these conventions, they have now passed into a customary international law. However, one of the great achievement was conclusion of 1982 UN Convention on Law of the Sea, which deals with the vital issues of the law of the sea, and it does so in a matter that has commanded a significant amount of support. Now many of the provisions either reveal the existing customary international law or will crystallize into new law in due course. So this was all about law of the sea. Thank you very much for attending today's lecture. See you in the next class.